As all keen math students will know, that's a Venn diagram. It uses overlapping circles to show the logical relationships between two or more sets of items. Now, until recently, it would have been impossible, I suggest, to draw a Venn diagram which featured on the one hand James Bond, the suave, sophisticated and fast-living spy, and on the other, adverse possession, probably one of the driest and most technical areas of land law. But thankfully, that Venn diagram can now be drawn, and it's all thanks to the case of Ridley and Ridley and Brown, which will come before the Supreme Court on the 21st of July, and in which I'm lucky enough to represent the appellants, Mr and Mrs Ridley. How so, I hear you ask? Well, let me explain. The Land Registration Act 2002 introduced what we still call the new regime for adverse possession in respect of registered land. Section 96 of that act disapplies the provisions of the Limitation Act 1980, which previously governed the limitation position in relation to registered estates in land on the basis of adverse possession. And Section 97 introduces Schedule 6, which contains the new regime. And paragraph 1 of Schedule 6, and in particular subparagraph 1, provides the gateway. So you can apply to be registered as the proprietor of a registered estate in land if you've been in adverse possession of the estate for the period of 10 years ending on the date of the application. Pretty straightforward language, no difficulty in interpreting what that means. Paragraph 2 provides for the registrar to give notice of the application that's made under paragraph 1 to the registered proprietor, so to the paper owner. And then paragraph 3 provides that the paper owner can require that the application is dealt with under paragraph 5 of Schedule 6. If the paper owner doesn't require the application to be dealt with under paragraph 5, then the applicant just gets registered as the new proprietor of the relevant estate. In the vast majority of cases, though, when the paper owner is put on notice that there's a claim to be registered as the proprietor of their title, they do require the matter to be dealt with under paragraph 5. That's paragraph 5. The whole aim of the new adverse possession regime was to make it harder for people to obtain land through adverse possession. And so the only way, as a putative adverse possessor, that you can obtain title through adverse possession is to fulfill one of 3 conditions called the first, the second, and the third condition. Ridley and Brown is all about the third condition, which has been called the reasonable belief condition. You can see there in subparagraph 4 of paragraph 5 of Schedule 6, there are 4 elements to the third condition. Ridley and Brown is all about the third of those 4 elements. So the statutory language requires that for at least 10 years of the period of adverse possession ending on the date of the application, the applicant or any predecessor entitled reasonably believed that the land to which the application relates belonged to him. And Ridley and Brown is a case about statutory interpretation, and it's all about what paragraph 5(4)(c) of Schedule 6 means. And there are 2 competing interpretations. Mr. Brown says that an applicant is required to reasonably believe for a period of at least 10 years ending on the date of the application for registration that the application land belongs to them, disregarding what he describes as a de minimis period, which is to be measured in weeks rather than months. That is what has been called the last 10 years interpretation. Mr and Mrs Ridley say that the language of paragraph 5(4)(c) requires an applicant to reasonably believe that the application land belongs to them for at least 10 years of their period of adverse possession. and it's the period of adverse possession which must end on the date of the application. And so the short point that's raised by Ridley and Brown is, in paragraph 5.4c of Schedule 6 to the 2002 Act, do the words ending on the date of the application, which you see in red there, do they refer to the period of adverse possession? That's what Mr and Mrs Ridley say. Or do they refer to the period of reasonable belief within the period of adverse possession, which is what Mr Brown says? This is a very basic plan of the affected land. Towards the top right of the picture, you've got a blue and a yellow quadrangle and a green quadrangle. They are together, the blue and the yellow, what Mr and Mrs Ridley bought in 2004 from their predecessors, Mr and Mrs Gales. Mr Brown bought his land, which is outlined in purple, in 2002. The green quadrilateral, the disputed land, was enclosed by Mr and Mrs Gales' predecessor in title, and Mr Shaw, way back in the 1980s, when he built a fence and planted a Leylandi hedge along the southern boundary of that green quadrilateral. So when Mr and Mrs Ridley purchased in 2004, they thought that the land that they had bought, the blue and yellow area, also included the green area. They held that belief until 2018. They got planning permission to build a new property, effectively in the back garden, in the yellow triangle. And the yellow triangle building, part of it was built on the disputed land. Now we come to the big reveal. What was the name of the new dwelling? Moonraker. Well, Moonrakers, but we're not going to let an S get in the end of a good story. That, for all of you who are wondering, lies in the middle of the Venn diagram. Moonrakers is what connects adverse possession, the Supreme Court. So they built Moonrakers, part of which was on what turned out to be Mr. Brown's land, even though they thought that it was their land. Mr. Brown wrote to them in October 2019 and said to them, I think that you're building on my land. In fact, he wrote under the provisions of the Party Wall Act, but that's not relevant. And in response to that letter, the Ridleys applied to the land registry to be registered as proprietors under the principle of adverse possession on the 20th of December. Mr. Brown was given notice of that application. Obviously, he objected, and the Ridleys required on the reasonable belief condition. And what they said was, we have reasonably believed that we owned the green land since 2004, up to the point at which Mr. Brown wrote to us in October 2019. And we've been in adverse possession of the land for that period and remain in adverse possession of it. So the matter was allocated to the first tier tribunal, went before Judge Bastin. He found that Mr. and Mrs. Ridley got through the gateway. He found that they had been in adverse possession of the land the whole time since 2004 and remained in adverse possession of it. And then he had to deal with the reasonable belief condition. And he had to deal with two matters. He had to deal with the legal interpretation, that question of last 10 years and any 10 years, And then he had to deal with when the Ridleys lost their reasonable belief. And Judge Bastin decided, in common with a majority, I would say, but by no means all first-tier tribunal judges who've had to grapple with this issue over the years, Judge Bastin decided that it was any 10 years that was the preferred legal interpretation. He found as a fact, though, that Mr and Mrs Ridley had lost their reasonable belief not in October 2019, when Mr Brown had written to them, but rather 18 months earlier, in February 2018, when they made the planning application for Moonrakers. But because he said it was any 10 years, there was enough time between 2004 and the loss of the reasonable belief in early 2018 to get past the any 10 years application, and so Mr and Mrs Ridley won, and he directed that they were registered as the proprietors of the disputed land. So the eagle-eyed amongst you will notice that because of the factual findings that the judge made, this was a case where it mattered whether it was any 10 years or last 10 years, because Mr and Mrs Ridley had lost their reasonable belief over 18 months before they made their application to the first-tier tribunal, to the land registry, so that if it was last 10 years, they couldn't satisfy the test. Mr Brown appealed, and he appealed on two grounds. First, he said that the first-tier tribunal had failed to follow binding Court of Appeal authority in the form of a case called Zarb and Parry from 2012, which was one of the first times that the Court of Appeal had to deal with the new adverse possession regime. And secondly, he said even if Zarb wasn't binding as a matter of strict ratio, then the judge was wrong anyway to decide that any 10 years was the correct interpretation of paragraph 5.4c. Mr and Mrs Ridley appealed against the factual finding that he'd made that they lost their reasonable belief in February 2018. Perhaps unsurprisingly, they didn't succeed in challenging the factual finding of the judge, and we need deal with that no more. The appeal was heard by the President of the Upper Tribunal, Mr Justice Edwin Johnson. He considered the grounds under three heads. Firstly, whether Zarb was binding. Secondly, if it wasn't binding, whether the FTT had given sufficient weight to it, and another Court of Appeal case called IAM and Chowdhury, which also proceeded along the lines that the last 10 years construction was right. And then if the answer to both of those questions was no, then whether or not, well, which was the correct interpretation, last 10 years or any 10 years. And in something of a blow to Mr and Mrs Ridley, Edwin Johnson J concluded that Zarb was binding on the construction of the reasonable belief condition. On the face of it, a surprising result. If you read Zarb, there was no argument about the construction of the reasonable belief condition. It doesn't appear to have been analysed in any of the three judgments of the Court of Appeal judges. I have to say, when I first looked at it, my immediate reaction was, this is Overton. He came to a different conclusion, and paragraph 71 to 101 of his judgment are well worth a read for anyone who's interested in the difference between the ratio of a case and what is Overton. It's illuminating, it's persuasive, and I can absolutely see why he decided as he did. So in light of that conclusion, he didn't need to go on and decide the third issue on the appeal, which is the correct interpretation. At my invitation, although it may have been slightly more desperate than that, I have to say, he did deal with the third head. And so what he went on to decide was, if he was wrong about Zarb being binding, was Zarb correctly decided? Was last 10 years the proper interpretation of the reasonable belief condition? And in a very detailed analysis, paragraphs 124 to 162 of his decision, he concluded not only that any 10 years was the correct interpretation, but that last 10 years was in fact absurd. And The rather unattractive position following that judgment then was that there had been at effectively High Court level confirmation that there was Court of Appeal authority in the form of ZARB, which was binding on Court of Appeal and all courts below on the proper construction of the reasonable belief condition. However, it doesn't appear that that judgment followed any argument at all about the construction of the reasonable belief condition, and nowhere in the judgments of the Court of Appeal can it be seen where they explain why it's last 10 years rather than any 10 years. And when the competing arguments on construction had been argued out before the Upper Tribunal, before Mr. Justice Edwin Johnson, he thought that it was pretty clear that it was any 10 years that was right rather than last 10 years. That's what lawyers call a bit of a mess, really. And in those circumstances, we felt that an appeal was being encouraged by the judge. Why go on and conduct all of that analysis about the reasonable belief condition if your conclusion was that you're bound by Court of Appeal authority? The Tribunal Courts and Enforcement Act of 2007 is not an act that I come across terribly often. But I do now know that Section 14A of it allows a leapfrog appeal from the Upper Tribunal Lands Chamber to the Supreme Court upon the grant of a certificate by the Upper Tribunal. What that allows you to do is effectively miss out the Court of Appeal and go straight to an application for permission to the Supreme Court. It seemed to me, anyway, that Mr. Justice Edwin Johnson knew very well about this, and it was a case where it was perfectly obvious that to go through the Court of Appeal before getting to the Supreme Court would be a complete waste of time, because if the Court of Appeal decided, in agreement with Mr. Justice Edwin Johnson, that ZARB was indeed binding authority on that issue, then all they would do is say, well, it's binding, and we'd have to go to the Supreme Court anyway. So, in both hope and, I think, expectation, in light of what he'd done, we asked Mr. Justice Edwin Johnson for a leapfrog certificate. He granted it. And we asked the Court of Appeal for permission to appeal, and they granted it straight away on paper. So this is obviously an issue that requires resolution. It is what the Supreme Court often call a short point of statutory construction. The Supreme Court is obviously well used to having to construe statutes. In the handout at paragraph 29, I've set out the test that they will apply from the case of R.O. and the Secretary of State for the Home Department. Construing a statute is not that much different to construing a contract. The words that Parliament have used are the primary source of Parliament's objective intention, which is what the Supreme Court will be looking for. So going back to the words of the statute, the parties before the Upper Tribunal acknowledged, as had the first-tier tribunal and the Upper Tribunal both found, that as a matter of language, it's possible to interpret or read paragraph 5.4c consistently with the last 10 years or the any 10 years construction. So linguistically, it's ambiguous. The important point, Mr and Mrs Ridley will argue, is that Mr Brown doesn't seek to argue for a literal interpretation of paragraph 5.4c. Mr Brown accepts that if you read the last 10 years interpretation literally, that requires an applicant for adverse possession to make their claim to the land registry or put their application into the land registry on the very same day that they cease to reasonably believe that they own the land. And in reality, that renders the statute completely unusable in a practical sense. Who is able to access legal advice, have the application drafted, and make it on the same day that they are put on notice that any belief they have that they own the land either is wrong or isn't reasonable anymore? And so what Mr Brown seeks to do is to put a gloss on the words of paragraph 5.4c, and what he says is that you have to introduce a concept of a period, which he doesn't define but describes as de minimis, between the loss of the reasonable belief and the date that the applicant's required to put their application in. And what Mr. Brown says is that there's a promptness test there. So as long as an applicant puts their application into the land registry promptly after they cease to have a reasonable belief that the land belongs to them, then they will comply with the last 10 years' interpretation of the reasonable belief condition. Me and Sam Healy from Deer Street Chambers, who I'm leading in the Supreme Court, have an undoubted advantage in that, unusually on an appeal, we will be saying to the Supreme Court what Mr. Justice Edwin Johnson said is right. And I've seen it written in commentary on the Upper Tribunal's decision that our appeal has largely been written for us by Mr. Justice Edwin Johnson. It's certainly helpful to be able to pray in aid what is a detailed and compelling analysis from the President of the Upper Tribunal. It's certainly unusual to be able to rely upon the judgment below effectively on an appeal, where you're the appellant. But ultimately, Mr and Mrs Ridley's core submission is a pretty straightforward one, and it's this: where the language of the statute, which according to all the authorities is the primary source of Parliament's intention, is consistent with the any 10 years construction, but it requires a substantial gloss to be put on it in order for the only version of the last 10 years construction that makes sense. It's the any 10 years construction that ought to be preferred. They will make additional points. One of those additional points is, what is this promptness requirement? What is this de minimis period? It produces an uncertainty which is not only not to be found in the words of the statute, but it would also produce a substantial risk of satellite litigation. And they've also got a policy argument. In an era where litigants are positively discouraged from using the courts and tribunals to resolve their disputes other than as an absolute last resort, the fact that the last 10 years construction would drive applicants into the land registry in the first tier tribunal without first providing them with a sensible period to conduct ADR, for instance, provides a policy-based justification if the Supreme Court decide to take it for preferring the any 10 years construction. So this will be the first outing for the new adverse possession regime in the Supreme Court, over 20 years on from the introduction of it. Whether it's any 10 years or last 10 years that the Supreme Court prefers, the decision will provide much needed certainty. What is uncertain is whether any of the judgments of the justices of the Supreme Court will sneak in any bond references.